Good afternoon and hello everybody. Welcome to our first March webinar, which is 8 mistakes that may invalidate your meeting or actions taken at the meeting. My name is Elena Gilbert. I will be presenting today. And as you know, for those of you who have done this before, we've got to go through a few housekeeping things before we move on to the good stuff so you can enjoy this wonderful meme in the meantime. So as I said, I am Elena Gilbert. I will be presenting today. And if you look at your screen, the bulk of your screen should be the PowerPoint. So you should be looking at Meeting Man. I am kind of off to the left of the PowerPoint. Hello. Hopefully you can all see me. Now, if you are having any audio or video issues during the presentation, at the bottom of the screen, there should be a little box that says no audio or video ? Click on that and it'll take you through a few steps and hopefully we can get it resolved that way. If it doesn't get resolved that way, please reach out to our education coordinator, and that's going to be Jessa, and her direct phone number is 303-991-2086. Her email, if you choose to reach out that way, is JL as in lamb, EDESM as in Mary, A at altitude.law. So please reach out to Jessa if you're having any problems that can't be resolved by clicking that button. Also, you can reach out to Jessa if you do not see your CMCA certificate emailed to you in the next couple of days. If you don't see it, probably by Monday at the latest, please either call or email Jessa and we can get that sent off to you. You will get 1 CMCA credit for attending this webinar. Last but not least, there will be a survey at the end. You guys are probably used to this. If you have time and are willing to, we always appreciate any feedback you can leave us. Whether it's good or bad or whatever, it really doesn't matter because that's how we improve our presentations to you. And we appreciate any thoughts that you care to leave with us. So without any further ado, let's go ahead and move on and get started here. So before we get to the actual mistakes, I do want to quickly touch upon just meetings in general. And I want to make it clear, and you already know this, I'm sure, there's really 2 basic kinds of meetings that we're dealing with in HOA world, and that is we're either dealing with a membership meeting or owner meeting, or we're dealing with a board meeting. And within those broad categories, of course, you'll see our subcategories. So with your membership meetings, it could be an annual meeting, it could be a budget ratification meeting, it could be a special meeting of members. But the point is that with a membership meeting, this is an opportunity for owners to vote on things, right? And there's only a certain amount of things that homeowners vote on. And so those are accomplished at a membership meeting, whether we're talking about elections, budget ratifications, approving modifications to your governing documents. Those are the types of things that we see at membership meetings with respect to voting. Our board meetings, of course, are the meetings where the corporation conducts its business, where the board makes the day-to-day decisions as far as, contracts, as far as whether or not we want to look into things, whether or not we want to make any repairs or improvements, common elements, whatever it is. So I just want to make sure that we are all on the same page with respect to the 2 basic kinds of meetings. For the purposes of today's webinar, most of the stuff I'm going to be talking about, most of these mistakes are targeted to our membership meetings because that's where we see most of the problems. If there are any issues with respect to board member meetings, I will point that out to you in each category. But just assume that we're talking about membership meetings unless I tell you otherwise. When it comes to the difference between our membership meetings and our board meetings, again, we already talked about what the difference is with respect to the type of business that gets conducted during those meetings. But there's also some differences when it comes to notice requirements, voting quorum, what decisions are appropriate in each kind of meeting, and owner participation. We're not really going to delve into a lot of this stuff today. I just want to put it out there and make sure we are all clear that there is a difference between the homeowner meetings and the board meetings. So at this point, let's go ahead and get started with our top 8 meeting mistakes that could be pretty detrimental to us. The first one is the improper notice one. I suspect anytime you attend a class or listen to a webinar that talks about meeting mistakes, you're going to hear about the notice issue. And I think at this point, almost everyone is aware of what's required, but I think it's a good refresher to go into this in some little detail, just to make sure, again, that we are remembering everything that's important and everything that we need to do. So when it comes to meetings, and again, this is a homeowner meeting, so think of your annual meeting in this case. We have to send out notice 10 to 50 days out. So at least 10, no more than 50 days before the meeting. This is really regardless of anything your bylaws say. The 10 to 50 days come from Kiowa, and this is a provision of Kiowa that applies to all communities regardless of when you were created. So in some cases, you will see something perhaps in your bylaws that say notice must be 30 to 60 days out. Does that mean that's what you have to do? No, we still have to comply with a 10 to 50 day notice under Kiowa. However, our homeowners, they don't know what Kiowa says or what the law requires, so it may behoove a board, in that case, to decide to send notice out 30 days. That's still within the 10 to 50 day requirement under Kiowa, but it also falls within the 30-day minimum requirement under the bylaws, and that will hopefully eliminate any questions or concerns that homeowners may have with respect to the timing of the notice. Snail mail. Unfortunately, Kiowa has not caught up with the times, and as of today, snail mail is still a requirement. The only alternative to snail mail is hand delivery, which I suspect most of you do not wish to do, because hand delivery means you're knocking on the door and you're actually giving the notice to the person. You're handing it to them. You're not just like taping it to the door. I don't think that would necessarily qualify. So in most cases, we are looking at snail mail, unless you're in a small community and you know everyone and you're comfortable going door to door. Oh, I'm sorry, I accidentally hit that. Unless you're comfortable going door to door, and handing them out. So if you don't snail mail and you don't physically hand it to someone, if you don't use one of those two, your meeting is not going to be valid. Any decisions you make at the meeting are not going to be valid, and you are likely going to have to redo the entire meeting because notice was improper. Here's the other one, physical posting. This is a requirement that says at some point before the meeting, it doesn't say how far before the meeting, you have to physically post notice of the meeting in a conspicuous location. Again, it doesn't tell you exactly where, but it says in a conspicuous location. One problem I'm seeing with some communities and some boards, even some managers, is that there is a resistance to doing the physical posting because of a fear that it's going to lead to increased crime that evening in the community, because somebody's going to drive by, a criminal's going to drive by, someone's casing the neighborhood, they see the sign, And they're like, great, no one's going to be home. They're all going to be at the annual meeting, so I can go ahead and break into a whole bunch of homes. Although I understand this concern, I will tell you, it's not something that will protect an association if you have to go to court. Someone challenges the meeting because we failed to physically post the notice. It's just not going to help us. A judge is going to say this was a statutory requirement. You have a clubhouse. You could have posted the notice at the clubhouse. You did not do it. You failed to comply with the notice requirement, and therefore your meeting is invalid. So be careful with the physical posting. Now, you can post it like 2 hours before the meeting if you want, but you got to post it at some point. So be very careful if you're one of those boards or community managers where you are just adamantly against it. It could come back and bite you if somebody were to challenge it. Now, obviously, your notice is going to tell you the time, the date, and the location of the meeting. If at the meeting there is a plan or there is an agenda item that includes voting on any amendment to a governing document, whether it's your articles, bylaws, or covenants, you will need to have mention of that in your meeting notice. This is one of the agenda items, okay? If you are planning on voting to remove any director, one or more or all directors, notice of that must be in that meeting notice as well. So what that means is you're at the annual meeting, and this has happened before with me, and there's a motion from the floor from a homeowner. Homeowner says, I motion we take a vote to remove all the current directors from the board. The answer is that is not a valid motion. That is not something that can be done because there was no notice of this action when we sent out the annual meeting notice. It wasn't in there. And because it wasn't in there, that's not an appropriate agenda item for today's meeting. And you can't do it. Same thing with amending the bylaws. I've seen homeowners on the fly go, well, we never get quorum. I motion we amend the bylaws to lower quorum. Again, can't do that if you didn't have anything in the meeting notice indicating that we were voting on that. And finally, virtual meeting considerations. I kind of have this little check mark throughout today's presentation because I want you to keep in mind that virtual meetings, although still meetings, do have kind of their own nuances and their own issues to deal with. In other words, how you do things during a virtual meeting is not always going to align with how we do them at a physical meeting. Whether it's taking attendance, whether it's collecting proxies, whether it's voting, it's all a little bit different. And so if you have a community that does rely on holding these types of virtual meetings, and most associations do, it seems it is continuing, the trend is continuing. People like their virtual meetings for the most part. So if your community holds virtual meetings, whether they're for the board or especially if they're for the membership meetings, I encourage everyone to consider at least adopting a virtual meeting policy if you haven't done so already. A virtual meeting policy is a policy that essentially supplements your current conduct of meetings policy, which is a required policy, to add additional steps and rules associated with specifically virtual meetings. It makes your job as community managers easier because now you have a step-by-step guide. It makes the board's job easier because now we know how we're going to do it every single time and it's going to be consistent. So do consider that. It's highly recommended if you regularly conduct these type of virtual meetings. All right. Meeting mistake number 2, not using secret ballots. There's actually two times or 2 instances where Kiowa says we have to use secret ballots. And again, this applies to all communities regardless of when you were created. So the first one is contested elections, which I think most everyone knows that by now. Contested election means we've got more people running than open positions, right? We have 2 open positions, we've got 5 people running. We've got 1 open position, we've got 2 people running. Those are considered contested elections, and they do require secret ballots. And there is no way around that. So if you're not using secret ballots for a contested election, does that invalidate the election? Well, if someone were to challenge it in court and went in front of a judge, I suspect it would invalidate that particular election. The other option, of course, is, or the other event that could trigger the requirement for a secret ballot is at a membership meeting, if you have 20% or more of the homeowners who are in attendance at that meeting. So it's 20% of those who are there. If they request a vote by secret ballot, we have to comply and do a secret ballot vote. Okay, otherwise there's no other specific type of vote or decision that requires a special meeting. So virtual meeting considerations, this is pretty big because when we have, if you guys recall back to COVID times when pretty much all our meetings had to be virtual and we had to do elections and we had contested elections, you can't really do a secret ballot vote if you have an electronic meeting unless you subscribe or obtain a platform, a virtual meeting platform that actually allows owners to sign in with their individual codes and passwords, cast their vote, and then that platform also allows us to then print out ballots if we need to without any identifying marks on there. If you have that kind of a platform, and I know some associations did get those, then it is possible to actually hold your secret ballot election during the virtual meeting. If, however, you don't have that type of platform, you are not able legally to hold a secret ballot vote during the meeting. Because what has to happen is people have to be able to cast their votes during the voting period, which has to be during the meeting. If a meeting is adjourned, we're done and you can't cast votes anymore. So that whatever 1 or 2 hours that you hold your meeting, homeowners have to be able to cast their votes at that time. And if you don't have a platform allowing them to do that in a way that it's secret, allowing them to do it in a way that protects the association from people voting more than once, and allows a printout of the ballot, then you can't lawfully do that, which means you're going to do an election by a mail ballot after the meeting is concluded. Now, I don't want to go into a whole lot of detail on mail ballots because that's, outside the scope of what this meeting is or this class is about. But just remember, if you're using a mail ballot, then that ballot and all the required information has to get sent to all the owners in the association. It doesn't just get sent to those people who were in attendance at the meeting. It goes to everybody. It's a completely separate legal process of voting that has nothing to do with the meeting. And just keep that in the back of your minds. I always recommend, if you're doing a mail ballot vote of any kind, that you work with your legal counsel, because the Nonprofit Act has a whole bunch of requirements of what needs to be contained in that packet, what kind of information has to be there, what the ballot has to say. And I have typically experienced situations that are not good when a board takes on drafting a ballot by itself. So please work with your counsel if you're doing that. Okay, number 3. Not having, or I shouldn't say not having quorum. Quorum itself. What kind of mistakes? Calculating quorum incorrectly can happen. And what a lot of folks don't realize is sometimes quorum is based on the total of all units or of all votes, and sometimes it's based on those that are eligible. You really need to look at your bylaws to figure out what it is. So, for example, let's say you have 90 units and your bylaws say that you have to be in good standing. In other words, current in your assessments, not in violation of the covenants, or the association takes away your voting rights. And out of those 90 homes, we have 10 folks who are either delinquent or in violation of their covenants. And therefore, their voting rights are gone right now. When you're calculating, let's say the quorum requirement is 10% of the eligible votes. So when you're calculating it based on everybody, it would be 9, right? We need 9 owners present to have a quorum. If it's based on eligible votes, then we need 8. So it's a different number. So when you are calculating your quorums, be careful, read the bylaws to determine exactly what is required. The other thing to pay attention to, is it a percentage of all the owners? Is it a percentage of all the votes? Or is it a percentage of the allocations? If you are on the board or managing a community that is typically condominiums with allocated interests based on square footage, obviously that could change. 10%, owners representing 10% of the total square footage or of the total votes is very different than owners representing 10% of the total units in the community. So again, you want to be very careful and read your bylaws when you're determining the correct number for quorum. Because to the extent you hold a meeting and you think you have quorum, but you actually didn't, guess what? That is not going to be a valid meeting. You're going to have to redo the whole thing. None of the voting conducted during that meeting is going to be valid. So make sure you know what the quorum requirements are. Just as an FYI, there are default quorums in both Kiowa and the Nonprofit Act if your bylaws are completely silent. It's very rare that I've seen bylaws be completely silent, but if you're a pre-Kiowa community, so created before July 1, 1992, quorum by default is 20%. If your documents are silent, and if you are a post-Kiowa community with less than, I believe, 1,000 units, it is also, wait, no, I just messed that up, you guys, scratch it. Nonprofit Act is 25%. That's the quorum. Kiowa, for post-Kiowa communities with over 1,000 is 10%, under 1,000 is 20%. So those are defaults. They don't come into play unless your bylaws or your documents are completely silent as to quorum. Okay, so probably not going to really impact most of us. Finally, virtual meeting considerations. Again, how do you take attendance at a virtual meeting? How do you calculate whether or not you have quorum? Slightly different than at a physical meeting. So again, those are the types of things that a virtual meeting policy would likely address or would address. Okay. Improper use of proxies. This one is kind of gaining notoriety. It seems to me I see more and more mistakes being made when it comes to the use of proxies. So let's take a few minutes and first of all talk about what is a proxy. So a proxy is not a ballot. It should never be treated as a ballot. A proxy is essentially a document that allows me to be present at a meeting without physically being there, right? How do I do that? Well, I give my proxy to someone else, and that person is at the meeting, and that person is now me. All the proxy does is create a legal connection and provide a legal right to that other individual to attend the meeting as me. Okay. There is no limit on who I can give my proxy to as a homeowner. I can give it to the mailman, I can give it to the garbage man, I can give it to my cousin 3 times removed. It doesn't matter. It does not have to be another owner in the community. So proxies are pretty wide open. Anyone can give anyone their proxy. You as an association cannot limit the use of proxies. What do I mean by limit? Well, I've seen associations have rules or try to add provisions to their documents saying a proxy must be submitted at least 2 days before the meeting starts, or 2 days before the meeting date. A proxy is only valid if it is delivered to the secretary. Owners may not obtain more than 2 proxies. Those types of provisions are limiting, and they are unlawful, and they cannot be enforced. Because under Kiowa, and this provision applies to everybody, it basically gives owners an unfettered right to attend meetings in person or by proxy. Okay? So if someone's attending by proxy, they are still legally attending that meeting. So telling someone you have to give me your proxy at least 2 days before the start of the meeting is like telling an owner who's attending physically, you have to get to the building where we're holding the meeting and wait for 2 days, because you have to be there at least 2 days before the meeting date. It's essentially the same thing. As stupid as it sounds, hopefully some of you are chuckling, but it's exactly the same thing. Just like you can't limit someone physically attending, we can't limit someone attending by proxy. We also can't limit how many proxies a homeowner or a person can bring. And the reason is because if I want to attend a meeting as a homeowner and I can give my proxy to anyone else, so can every other homeowner in the community. They can give their proxy to anyone else. And a lot of times there's concern. We've got a homeowner who's knocking on doors. They're politicking. They want to elect their friend to the board. And everyone is concerned. They're going to go and get like 50 proxies and they're going to be able to elect that person because they're going to have most of the votes. Well, that is true, but I will tell you one thing, and that is there is nothing in the law that prohibits our boards from doing the same thing. I was on the phone yesterday with a board member who was also very concerned. They have an upcoming annual meeting. She was very concerned that this one homeowner is out there getting proxies. He's out there publishing false information about the board. And I said, well, why don't you respond with the specific facts that explain kind of what the reality of the situation is? And if you really want to go knock on doors and get proxies, why don't you do that? And she said, I didn't think the board was allowed to do that. Well, there's nothing that stops the board from doing that. You want to be careful in the information you put out there as a board because obviously it needs to be factual. Stay away from your opinions, stay away from name calling, but to the extent there's facts, you can put those out there. There's nothing that stops you from doing that. If you want to solicit proxies from owners who will not be attending the meeting, there's nothing that prohibits you from doing that. It's not a conflict of interest. That doesn't even apply in this case. So don't limit how many proxies a homeowner or anyone can bring to any meeting because that's not going to be enforceable. Another myth that I'd like to clear up is that the association is not required to provide proxy forms when they send out their meeting notices. I know most of you send out your meeting notice and you add a proxy form. That's really more for convenience. It's not required by the law because we want to have a proxy form that we can understand. If we don't provide a proxy form, owners can still issue proxies to other people. They just have to create the document themselves. And to be honest with you, the law does not have a whole lot of constraints on what a proxy form looks like. The only requirement is we need to have it dated and we need to have it signed by the proxy issuer. Other than that, there's really not much out there. Now, for practical purposes, obviously we need to know who the proxy is being issued to, or if it's not issued to anyone, whether it's just being used for quorum purposes. So that's an important thing for us to know. And recently, the law changed to say a proxy really cannot exceed 11 months no matter what. It used to be that it was 11 months unless there was a longer time frame. Now it's 11 months unless there's a shorter time frame. So they can't exceed 11 months. But the long and short of it is you don't have to, as an association, provide proxy forms when you send out meeting notices. But it makes sense to do that because it's just so much easier to use a form that you're familiar with, that you know what's in there, that has all the language you want with respect to the right to substitute, and it works on adjourned meetings and things like that, okay? Absentee ballots is a big, big no. That's not the same thing as a proxy. In fact, we can't really use what's called an absentee ballot. There's no mention in Kiowa of an absentee ballot. It doesn't really exist. We really are voting by a ballot at the meeting, or if we're not voting at the meeting, we have to vote by the mail ballot process. As I mentioned previously, that is governed by the Nonprofit Act. Those are the only two ways we're going to vote, and they're mutually exclusive. So what you don't want to do is hold an annual meeting and allow people to submit their ballots by mail to be used in conjunction with people voting at the annual meeting. You can't do both. It's one or the other, okay? And finally, virtual meeting considerations. Again, you can see how use of proxies, collecting proxies, proxies being turned in becomes a bigger issue when it comes to our virtual meetings, right? So again, this is all membership meetings. So keep that in mind. On a final note, remember this: proxies may be terminated, canceled out, vetoed, whatever. They may be canceled by the person issuing them in one of two ways. They can send a written notice to the association saying, please cancel my proxy, I don't want to issue it, or they can attend the meeting and vote. If the homeowner actually is in attendance, you take that proxy, you rip it up, it's no longer a valid proxy. All right, so that's really the issues with proxies. Be careful not to limit their use. Next, budget ratification meetings. So there are a few things that could go wrong here. One is timing and notice. So remember how when we first started off, I said your homeowner meetings, you got to have 10 to 50 days notice. Well, for budget meetings, what the statute says is you have to do notice as required in your governing documents, so in your bylaws. If you do have that bylaw provision that says you have to send notice 30 to 60 days out, you will need to follow that and not the 10 to 50 day, because we are specifically instructed in Kiowa that for this type of meeting, we have to follow what our bylaws require, okay? So when it comes to notice, make sure you're following the bylaws and the timing set forth in your bylaws. Still has to go by snail mail, still have to do physical posting of it like you would with an annual meeting. Those parts are, there's no difference there. The other thing to remember with the budget ratification is that that must be done at a meeting. You cannot use the mail ballot process because Kiowa specifically requires a meeting. The meeting can be physical, the meeting can be virtual, but you have to have the meeting. So no mail ballot option for the budget ratification. What else? Budget ratification meetings do not require a quorum. That's another exception. So if nobody shows up, great, it's going to be ratified. However, I want you to be careful because If you are doing your budget ratification as part of the annual meeting, in other words, you're having your annual meeting, we have an agenda item on the meeting agenda that says we are going to ratify the budget as part of the annual meeting, you will need quorum because annual meetings require quorum. You can't get around that. Therefore, our best bet is to have the budget ratification meeting be its own meeting. Now, you can hold it the same day as you hold the annual meeting. You can do it as 2 back-to-back meetings. The key is when you're sending your notice out, you need to make it clear. 6:30 p.m. budget ratification meeting, 7 p.m. annual meeting, or immediately following that annual meeting. You need to make sure that you are clarifying these are 2 separate meetings. That way, if you don't have quorum for your annual meeting, the budget ratification meeting is separate and you don't need quorum for that and you can still ratify your budget. So if you're not already doing it this way, I would recommend you consider doing it as 2 back-to-back meetings, especially if you have a hard time getting quorum to your annual meetings. The other thing to remember, voting versus veto. So if we're falling back on the Kiowa budget process, it's a veto, which means people have to say no. And it's a majority of all owners. I know some of you say, oh, it's 67%. No, it's a majority of all owners that have to veto, or a higher number if a higher number is specified in your declaration. Okay, so if your declaration doesn't specify any higher veto requirement, it's automatically a majority of all your owners. And this can typically be done without having to do any kind of ballots, because if you take attendance and you start the meeting and you don't have a majority of all your owners in attendance when you start the budget ratification meeting, it is automatically ratified because there's not enough people there to veto the budget. So it can't be vetoed, it's ratified. You ratify it, you adjourn the meeting, you go into your annual meeting, and then you can proceed to have a discussion about the budget there. Again, if you're doing your budget ratification meeting virtually, think about what that means, how you would run that, and whether or not there'd be anything really different about it. Again, if you have your policy in place, you're good because you got all your steps lined out in the policy. Okay, special meetings. Let's talk about homeowner meetings, and then we can briefly touch on board meetings. So the board can call a special meeting of members, right? All right. But what if homeowners want a special meeting? How does that work? So regardless of anything you have in your documents, Kiowa has a provision that applies to all HOAs regardless of when they were created. And that provision says you need a request from, you can't exceed 20% of all your homeowners. So you need a request from 20% of your homeowners, or a smaller amount if that's what your documents specify, but it can't be higher. A lot of older documents require a request from 25% of the homeowners before the board has to schedule a special meeting. Just know that's void. It's 20% under Kiowa regardless of when you were created. So if you get something from homeowners representing at least 20% that request a special meeting, you as the board have to call it. You have 30 days within which to send out the notice. So in that 30 days, you can look at the request. You can confirm that the people who signed are actual homeowners, not renters. You can make sure that there's not double signatures. You can make sure there's at least 20% in there. But at the end of the 30 days, assuming that they did get 20% of the homeowners to sign off on this, you have to send out the meeting notice, okay? What if you don't, as the association? If the association fails to send out the meeting notice within that 30 days, the homeowners who requested the meeting can do it. They can send it out, they can run it, they can do whatever they want. So don't ignore homeowner requests for special meetings. When do we get those? Well, most of the time you get those requests when there's a board recall on the horizon, right? A lot of times homeowners are just not happy. They want to recall the board or a specific board member or whatnot. But sometimes they're for other reasons. So remember, you have 30 days to send out the meeting notice. The meeting notice follows the same notice requirements as all our other homeowner meetings, so 10 to 50 days. Okay, same method of delivery, you still got to do snail mail, still got to post, before the meeting, all that stays the same. So hypothetically, you could stretch out the meeting to about 80 days out from when you get the request. So if you don't send your meeting notice for 30 days, and then you have a 50-day meeting notice, that's 80 days total. You could stretch it out. Most boards don't want to do that because it's just why, right? Let's get it over with. Let's call the meeting. Let's get it done. But you could. The agenda, well, so here's the thing. With special meetings, don't make this mistake. Special meetings, you can only vote on those items that are specifically listed in the notice and on the agenda. So let me give you an example of how that could work against us if we aren't careful. And this has actually happened. Homeowners request a special meeting of the association to remove the entire board. Board sends out notice within the 30 days like it's supposed to with the agenda, and the notice says this is a meeting to vote on removal of the entire board. The agenda says vote to remove entire board. That's it. They hold the meeting and the board is removed. Oh, great. What are we going to do now? Because there's nothing in the meeting notice or agenda that says we can elect a new board if this one is removed. So what do we do now? We have an association that has no board and it cannot elect a new board at this meeting. Because if it does, that whole election is going to be subject to challenge and probably not hold up because we did something at a special meeting that we weren't allowed to do. So be careful with special meetings. Think them through when you are preparing your notices and sending out your agendas. Don't leave yourself in a lurch, especially if one of the issues is removing board members. We want to be able to have a substitute board elected at the special meeting if the board gets removed. Who runs the meeting? It's been our position that the board president, whoever you typically have run your homeowner meetings, will run this meeting until and unless they are removed. That is the job of the board president. That can be delegated to another board member or the community manager, but the homeowners who requested the meeting do not have a legal right to run that meeting unless the association fails to actually call the meeting within the 30 days, in which case it's all on those owners. They can call it, they can run it, they can do what they want, they can go crazy with it. Okay, so be careful with the special meetings as well. Improper use of executive session. So there's only 6 acceptable reasons to go into executive session. They are all listed here. I don't need to read them, you can read them. The problem that I see is sometimes boards go into executive session to talk about things that don't fall under any of these 6 items. And that's a problem because Kiowa says all board meetings, oh yeah, so this is a board meeting issue, right? So all board meetings have to be open to owners. You can't prohibit owners from attending your board meetings. That being said, you don't have to provide them with notice of your board meetings. That's not a requirement, which strikes me as very odd, but that's always been the case. But you do have to allow them to attend. What does this mean? Well, in my mind, it means if you have a homeowner calling you saying, when's the next board meeting? You cannot say, haha, I'm not going to tell you. You got to tell them where it is, when it is, and if it's virtual, you got to give them the link. Okay? You can't hide that from your homeowners. And during your board meetings, you have to make decisions in front of the homeowners, except for if you're going to be discussing one of these 6 things. Remember, you can make decisions in executive session. That's another rumor out there that you can't make any decisions in executive session. You can. The only thing under Kiowa you cannot do in executive session is adopt rules and regulations. That you have to do in an open meeting. But other decisions you can make. And with, if you all recall, HB 1137, we're all still suffering the aftermath of that. But one of the things that it did do is it did require us to go into executive session to discuss delinquencies and to turn them over and to have our violation hearings. So now we do those in executive session. But be careful with your boards and be careful what you discuss during executive session, because if it's anything other than these 6 items here, it's not going to fly and you are exposing yourselves and the association to liability. Finally, improper motions from the floor. You know, there's tons and tons of questions today, so I'm kind of rushing through here a little bit so I can get through at least a bulk of the questions. There's like 42 in there right now. All right, so improper motions from the floor. That's kind of the last meeting mistake I want to talk about. And this happens in both board meetings and homeowner meetings. So in membership meetings, so often homeowners kind of throw out their motions and say, well, because it's a homeowner meeting and they think they can motion to do whatever they want. I motion we get a new landscaping company. You'll hear things like that. I'm sure you already have from homeowners in the audience. And they think it's okay. And boards actually entertain those. But the issue is they're not okay because homeowners can only motion to vote on things that the homeowners have a right to vote on. Day-to-day corporate decisions, such as use of contractors, such as maintenance, that is all within the purview of the board. And the board is the entity that makes that decision on behalf of the corporation. So what's the problem if we let homeowners make that decision instead of the board? Well, the ultimate problem is the board has the liability exposure for all decisions of the corporation because we are essentially the brain of the corporation as a board. We make the decisions and the buck stops with us. If you're shifting that responsibility to the homeowners or anyone else for that matter, and they make a decision that's wrong, not in good faith, ends up having a lot of negative consequences, guess who's on the hook for that decision? It's the board. It's not the homeowners who made that decision, it's the board. So for that reason, don't let go and give someone else control over something that you have ultimate responsibility for. Don't do it. So when you get motions from the floor to get rid of the contractor, or change management companies, or to do something else, it's important to explain to the homeowners that that's not an appropriate motion because this is not something that the homeowners decide. This is something that the board decides, and that is not appropriate for this type of a meeting. Board meetings, homeowners who are in attendance, yes, they're open to homeowners, but guess what? Homeowners cannot make motions at board meetings, right? So be careful with that. And if you have homeowners saying, I motion, we vote on this, well, that's all nice and good, but this is a board meeting. This is not a homeowner meeting. You do not have a right to make motions. The only thing you have a right to do is speak when you're recognized by the chair. You have a right to speak before the board votes on something and provide your opinion. But that's all you have a right to do as a homeowner attending a board meeting. Now, I'm going to tell you, there's a lot of nuances when it comes to meetings. And those of you who have been around a long time and have been doing this, you have seen how this plays out. You've seen the problems that arise, when things aren't done correctly. So there's a lot of things we're not talking about today just because it's impossible to fit it all in to this 1 hour presentation. But I totally agree with this meme because that's what I always do. Like, thanks, everyone. Yeah, I participated. Thanks. All right. I'm going to start at the beginning of the questions here and kind of go through them as many as I can. First question. So when we say that these are requirements under Kiowa, including pre-Kiowa communities, does this also apply to older HOAs that do not own common interest property? So if you have an older HOA, chances are they're subject to it. The only way they would not be subject is if you're not collecting mandatory assessments, or you've got like a $300 or $400 cap on assessments. There's some very specific exemptions. But if you're collecting assessments and you're an older community, you are still 99 out of 100 times going to be subject. In the meeting notice, decision is objected to by a member. Do they have a timeline to object? Homeowners do not have the right really to object to the notice. If you're talking about that we did something wrong, the association did something wrong, and the homeowner is calling us out on it, well, hopefully they do it before the meeting, and hopefully the association consults with legal counsel, and if it needs to change things and redo the notice or reschedule the meeting date, then it does that. But there's no specific time within which a homeowner has to call us out on it or they lose their right, if that's what you're asking. Is posting it notice on the portal under the calendar sufficient? It is not sufficient to comply with the posting requirement because that requires physical posting. So a physical piece of paper has to be posted. Posting it on the website is encouraged, but it does not replace the physical posting. What if you don't have a clubhouse or a community association board? So if you have a community like that, we've seen associations do sandwich boards at the entrance of the community. If you have like entrance monuments, we've seen flyers posted by mailboxes because most communities have mailboxes. If you've got none of that stuff and you've got no common elements, then you can say we can't post because we don't have a conspicuous location. But that's very few and far between. Who is to say that I didn't post it and the wind removed it, or a tenant or owner took it down? That's absolutely true. Who is to say that? And that wasn't my point. My point was if a homeowner is going to allege we didn't post it and we really didn't post it, and you are not willing to perjure yourself under oath in court, which I would hope most of us would not do, the meeting's going to be invalidated. Would you then find a place to post the notice in the neighborhood? Would I then? I'm not sure what that means. Would I then find a place? I would say, like I said, if you've got mailboxes, if you've got an entrance monument, those are good alternatives. If you don't have a clubhouse or something like that, if you don't have either of those, I think you can make a pretty good argument that you just don't have anywhere to post it. That's conspicuous. Should minutes be taken at any or all meetings? So yes, meetings should be taken when decisions are being made. The purpose of minutes is to have a corporate record of corporate decisions. And that's really the purpose of minutes. It's not to do a he said, she said. It's really to have a record of the decisions, the motions and the votes, the decisions. So anytime you're doing that at a meeting, regardless of the type of meeting, you should have meeting minutes. Can you still amend even if not a notice? So I assume you mean, can we still amend a document at a meeting even if we didn't put it in the notice? No, you cannot. And I've seen that happen. There was a community that had a really hard time getting quorum, just a horribly hard time. And they had an annual meeting, and by some miracle, they actually got quorum at the annual meeting. And somebody motions, I motion we amend the bylaws now that we have a quorum to actually lower quorum, which would have been great if they had said that in the meeting notice that we're going to vote on this. But they didn't. And so unfortunately, they could not use that meeting to vote on an amendment to their bylaws. So it does have to be in the notice. Can we be provided with an example of a ballot? I would recommend just probably doing a Google search. Most ballots are pretty straightforward. If you're talking about a mail ballot, that's kind of a different issue. And, you know, those are, again, I'd still do a Google search to see if you can pull up some samples, but that should not substitute for working with the association's attorney, because what you pull up may be from a different state and may not necessarily be compliant with our mail ballot requirements. Clarification, please. Proxies. I'm gathering that limiting proxies to annual meeting and excluding budget ratification would not be allowed. You can't tell people not to bring proxies to a budget ratification meeting, but you don't have to provide them with proxy forms for that meeting, which is what a lot of associations do. They'll send out the notice for the annual meeting and the budget meeting, and the proxy form they attach will say this is only for the annual meeting. So it can't be used for the budget meeting. But that doesn't mean homeowners can't create their own. And if they do, and they bring it to the budget meeting, we do have to honor them, assuming they're dated and signed. And we can, you know, understand what's in there. What if it is a directed proxy? So not much difference with a directed proxy as with any other type of proxy. And one thing I want to remind people of is because proxies are not ballots and they're simply agreements between two individuals for one individual to represent the other one at a meeting, they are directed proxies. When you get it as a board, when somebody's checking in, they give you their directed proxies, please don't give them a ballot and fill it out, because that's not your job. It's that proxy holder's job to fill out the ballot in the way that he or she agreed to. If they don't do it, that's not the association's issue. That's between the two people, the proxy issuer and the proxy holder. It's not our job, nor do we have authority to enforce the proxy issue, okay? So keep that in mind. Can a board use confidential owner emails to solicit proxies? So yes, as a board, I mean, as long as you're not disclosing those email addresses to anybody, you can. Because what Kiowa says is email addresses cannot be disclosed to homeowners unless the specific homeowner is approving their email address being disclosed. So if you're not disclosing those, then yeah, as a board member, you have access to all information. What if a homeowner submits a proxy but is not eligible, Is the proxy still good? So if the proxy issuer is not eligible to vote, then obviously we can count the proxy towards quorum, but we're not going to give you a ballot for that proxy. If someone shows up at the meeting, I'm a homeowner, I'm delinquent, I can't vote, but I bring you a proxy from someone who can vote, you are going to give me one ballot for that proxy. You're not giving me a ballot for myself because I'm not eligible to vote, but you're giving me a ballot for the proxy issuer because they are eligible to vote and I'm authorized to fill out that ballot on that person's behalf. Oh, goodness gracious. It's 1 o'clock. I know I probably only got through half of you. As I always say, my email address is up there. Please email me if you have questions that I haven't answered. And I will try my best to respond to all of you within, like a day or two and provide you with responses. Again, I'm really sorry. There's just not enough time to go through everything. And with respect for all your times, I'm going to go ahead and end this, but please email me. Feel free. Thanks for joining us, everyone.